3 generations of my family worked this land. One morning, a stranger's bulldozer sat parked on my front pasture. The HOA president smiled and handed me a sold notice. Neighbors gathered on the road, whispering, filming everything on their phones. I didn't yell. I just nodded slowly. Somewhere behind that calm face, a lawyer's mind was already working. 2 board members suddenly stopped answering their phones that week. By the end of that summer, someone else would lose their home. My name is David Marsh, and I grew up on 1,700 acres my grandfather cleared with a mule and a hand plow. After law school in Austin, I came back to help my aging mother, Ruth, run the ranch while quietly practicing real estate and title law from a home office nobody in town knew existed. Willow Creek Estates, the gated subdivision that had grown up along our eastern fence line over the last decade, was not part of my land, never had been, and never would be, or so I believed, right up until the morning everything changed. Deborah Voss ran that HOA like a small kingdom. She'd moved from Dallas 12 years earlier, married a local contractor named Frank, and by sheer force of committee meetings and passive-aggressive newsletters, made herself president for 3 consecutive terms nobody else wanted. My father had died when I was 26, young enough that I still sometimes reached for the phone to call him before remembering, and running the ranch afterward became less a burden than a way of staying close to a voice I still heard clearly in my own decisions. Deborah didn't like that my ranch sat there, unmanicured and unbothered by her rules, right at the edge of her pristine cul-de-sacs. She called it an eyesore in 3 separate community emails before I'd ever spoken a word to her directly. The first time we actually met, she pulled her SUV onto my gravel drive uninvited and told me my unkempt fencing was lowering property values for the whole subdivision. I explained, politely, that my ranch had never been part of Willow Creek's covenants. She looked at me the way people look at something they've already decided to remove. "We'll see about that," she said, got back in her Range Rover, and left a business card stamped Willow Creek HOA, President stuck under my mailbox flag. My mother remembered Deborah's husband Frank from decades earlier, back when he tried to buy a chunk of our land from my grandfather for a development scheme that fell through. My grandfather refused him flat, and Frank never forgot the insult. My grandfather never spoke much about that failed 1987 deal, only mentioning once, briefly, that some men couldn't accept the word no gracefully, and that land bought under pressure never really belonged to the buyer, no matter what paper said otherwise. I didn't think much of that old history at the time. Old grudges, I figured, fade with the years. I had no idea Deborah Voss had been quietly nursing her husband's decades-old resentment like kindling, waiting for the right wind. Over the following months, the newsletters grew stranger. One mentioned future community expansion opportunities to the east. Another referenced a 1987 annexation clause nobody in town had ever heard of, tucked into a paragraph about long-term planning. I filed those newsletters away without much thought. I was busy closing title work for clients in the city, keeping the ranch's books, and driving my mother to her cardiology appointments twice a month, an hour each way to San Antonio. My daughter Emma was away at college, studying environmental science, dreaming of coming home one day to run the ranch sustainably. Every phone call, she asked about the horses, the creek, the old barn her great-grandfather built. That land meant everything to her. I promised her nothing would happen to it. I believed that promise completely. I had the deed, the survey, The county records, everything clean, everything mine, filed and verified the way only a title attorney bothers to actually check. Still, something about Deborah's tone had started to worry me enough that I quietly pulled the full title history on my own property that spring. Just as a formality, I told myself, nothing more than professional habit. I began, quietly, to reread every newsletter Deborah had sent over the previous 2 years, this time hunting for patterns rather than simply irritation, and found references to community land assets scattered through at least 6 separate issues. Always vague, always unexplained. None of it would have meant anything to a casual reader. But laid end to end, chronologically, it read like the slow, careful groundwork of someone building public justification for a claim she hadn't yet made, a claim she was clearly already planning. What I found buried in an obscure 1987 filing made my stomach drop. A vague, unrecorded planning amendment referencing a boundary adjustment between our 2 properties, allegedly signed by my grandfather, that I had never once heard mentioned in my life. The signature looked wrong immediately, too smooth, too modern. Nothing like my grandfather's cramped, arthritic handwriting from his later years. I photographed the document and said nothing to anyone, not even my mother. Not yet. A week later, a certified letter arrived from Willow Creek HOA's legal counsel, informing me that 70 acres along my eastern boundary had been reclassified as shared common reserve under that same 1987 amendment, and back assessments were now owed. The letter listed a number that made no sense, 19 years of dues on land I'd never agreed to place under any HOA, totaling just under $200,000, with a 30-day window to pay or face a lien. I called the number on the letterhead. A receptionist transferred me straight to Deborah Voss, who answered in the same clipped, satisfied tone she used at community meetings. "I did warn you we'd see about it, David," she said. I told her the document was fraudulent, that my grandfather's signature had been forged, that I was a licensed attorney and knew exactly what I was looking at. She laughed, actually laughed, and said the board had already voted unanimously to proceed. That word, unanimously, stuck with me. In a community of 400 homes, getting every board member to agree on anything, let alone a boundary dispute with a neighboring ranch, required either genuine consensus or something closer to control. I began quietly requesting board meeting minutes through the county's public records office, the same way I would for any client facing a hostile HOA. What came back was heavily redacted, missing pages, and conveniently silent on any actual vote count. My mother, when I finally told her, went pale. She remembered something I never had, a story my grandfather told once at Thanksgiving about a man named Frank Voss who'd threatened, back in the 80s, that he'd get that land one way or another. I didn't sleep much that week. Not from fear exactly, but from the particular, cold clarity that comes when you realize someone has been planning something for a very long time, and you are only now catching up to it. The lien notice arrived formally 2 weeks later, filed with the county clerk's office and stamped with an official seal. My 70 acres, including the old windmill and half the eastern pasture, now carried a legal claim from an HOA I'd never joined. I drove straight to the county clerk's office to dispute the filing in person. The clerk who processed it, a young man named Tyler Ross, turned out to be Deborah Voss's nephew, freshly hired 6 months earlier into the records department. Tyler was polite but unhelpful, insisting the paperwork had come through properly, and that any dispute needed to go through the HOA's own internal arbitration process first, a process Deborah herself, as president, would ultimately oversee and control. I remember thinking, driving home from the clerk's office that day, that a records flood convenient enough to destroy exactly one document, and no others from the same era, strained credibility past any reasonable point, the kind of excuse a person offers when they've stopped worrying about being believed. I requested the original 1987 filing to compare handwriting and ink against verified samples of my grandfather's other signed documents from that era. Tyler told me the original had been damaged in a records flood 3 years prior, and only the copy remained. That was the first outright lie I caught in real time, and it settled something in me. This wasn't a misunderstanding or an overzealous board overstepping its bounds. This was a deliberate, coordinated fraud, and I was going to need real evidence. I started keeping a private file, copies of every letter, every email, every inconsistency, time-stamped and organized the way I'd build a case for a client. I told no one at Willow Creek what I was doing. Deborah believed I was simply upset and outmatched. At the next open community meeting, I stood up and calmly stated, for the public record, that the 1987 amendment appeared fraudulent and that I intended to challenge the lien through proper legal channels. Deborah's smile didn't waver, but her knuckles went white on the podium. A woman I didn't recognize, sitting near the back, caught my eye afterward and slipped away before I could speak with her. I later learned her name was Linda Pham, the HOA's treasurer, and she'd been quietly troubled by the board's finances for over a year. Linda didn't approach me that night. She wasn't ready yet, and honestly, neither was I. But something had shifted in the room. A few neighbors who'd always trusted Deborah completely were starting, just barely, to ask questions out loud. Deborah noticed the shift too. The following week, new flyers appeared around the neighborhood describing my ranch as non-compliant, blaming loose livestock and overgrown brush for a supposed rattlesnake sighting near the community pool. Though no such sighting had actually occurred. My mother, 74 years old and recovering from a minor heart procedure, found one of those flyers taped to our mailbox. She cried that night, not from fear, but from the humiliation of being painted as a menace on land her own father-in-law had tamed by hand. That was the moment my patience, already thin, ran out completely. I was no longer just defending a boundary line. I was defending my mother's dignity, my daughter's inheritance, and the memory of 2 men who'd broken their backs for this dirt. I hired a forensic document examiner out of Austin, someone I'd worked with on contested wills before, and paid him privately to analyze the 1987 filing against verified exemplars of my grandfather's signature from bank records and old land transactions. That night, I sat alone at the kitchen table long after my mother had gone to bed, staring at the auction notice under the lamplight, reading it over and over as if enough repetition might change the numbers or the date printed at the bottom. I thought about calling Emma right away, but decided against waking her with panic she couldn't do anything about from 300 miles away. Instead, I made coffee I didn't drink, and started a list, every fact I could verify, every fact I couldn't. While I waited on those results, Deborah escalated in a different direction entirely. She petitioned the board to fast-track a compliance foreclosure clause buried deep in the HOA's bylaws, one rarely invoked, allowing liens to convert into forced sales after 90 days of non-payment. I called Marcus from the hospital parking lot that same evening, exhausted and furious in equal measure, and he told me plainly that timing a vote around a family's medical crisis, if provable later, would matter far more than Deborah currently understood. I hadn't paid the assessment, obviously, since I disputed owing it at all. That silence, that refusal on principle, was exactly the 90-day clock Deborah needed. She'd engineered the entire dispute to hit that threshold before my legal challenge could even reach a judge. My attorney friend in Austin, a real estate litigator named Marcus, warned me that HOA foreclosure statutes in Texas, while narrow, were sometimes abused by aggressive boards precisely because homeowners assumed, wrongly, that no HOA could actually seize land it never legitimately controlled. Marcus filed an emergency injunction request on my behalf to freeze any foreclosure action until the forgery claim could be heard. The judge, overloaded with a backlog of cases, set a hearing date nearly 6 weeks out, 6 weeks Deborah intended to use fully. In the meantime, my mother's health took a frightening turn. A second cardiac episode sent her to the hospital in San Antonio, and I found myself splitting every waking hour between her bedside and the growing pile of legal documents on my kitchen table. Deborah, apparently informed of my absence through the neighborhood grapevine, chose that exact week to hold a special emergency board session, conveniently scheduled for a Tuesday morning she knew I couldn't attend, buried under 2 days' notice on the HOA's private forum. At that session, the board, Deborah, her husband Frank, a rubber stamp member named Gary, and one absent seat left conveniently vacant, voted to proceed with the compliance foreclosure sale, citing urgent safety concerns and community financial harm from my unpaid balance. I learned about the vote only after returning from the hospital, exhausted, to find a notice stapled to my gate announcing a public auction of my eastern 70 acres in exactly 21 days, conducted by a firm Deborah's own husband had personally selected. Marcus called it borderline illegal on its face. But borderline in a slow-moving county court system meant very little against a hard deadline. We filed everything we could: emergency motions, forgery affidavits, the forensic examiner's preliminary findings, into an overloaded docket. The forensic examiner's report came back conclusive. The 1987 signature was a traced forgery, likely created from a genuine autograph on an old land patent, with telltale hesitation marks a real signature under normal pressure would never produce. I filed that report immediately, but Deborah's camp had an answer ready: a supposed witness to the original 1987 signing, an elderly man named Chester Boyle, who claimed under a notarized statement to have watched my grandfather sign the amendment personally. Chester Boyle, turned out, had been Frank Voss's business partner in that failed 1987 development deal my grandfather had rejected. The witness wasn't neutral at all. He was the very man who'd stood to profit from the land back then. I couldn't prove Chester was lying outright. Not yet. But the coincidence was glaring enough that even the skeptical judge handling our injunction agreed to expedite a partial hearing, moving the 6-week wait down to just 10 days before the scheduled auction. Deborah's confidence, for the first time, showed a hairline crack. At a chance encounter outside the feed store, she told me I was making a fool of myself fighting the inevitable, but her voice had lost some of its earlier polish. My mother, discharged from the hospital but weak, insisted on attending the abbreviated hearing herself, wheelchair and all, to testify about the story her father-in-law once told of Frank Voss's old threat. The judge listened carefully, taking careful notes. I remember standing in that courthouse hallway afterward, Marcus beside me, both of us quietly relieved by the 60-day delay, even as we understood how thin a victory it actually was. A temporary wall against a flood that hadn't stopped rising. Chester Boyle's notarized statement, under cross-examination from Marcus, began to fall apart almost immediately. He couldn't recall the date, the season, or even which room of which building the alleged signing supposedly took place in. Still, the judge, cautious by nature, declined to void the lien outright at this preliminary stage, ruling only that the scheduled auction be delayed 60 additional days pending a full forgery investigation. A partial win, but not the clean victory we needed. Deborah spun the delay in her weekly newsletter as a temporary procedural pause, reassuring residents the community's rightful expansion land would still be secured soon, framing me publicly as an obstructive litigant hiding behind legal technicalities. That newsletter reached farther than I expected. A few neighbors who'd once waved friendly at the mailbox now avoided eye contact entirely, having absorbed months of carefully seeded narrative painting my family as the problem, not Deborah's fabricated paperwork. It stung more than I expected, watching people I'd known for years choose comfortable belief over inconvenient truth. But I reminded myself, and Emma over the phone that night, that public opinion wasn't evidence, and evidence was what would ultimately win this. During that 60-day window, I quietly hired a private investigator, a retired county records auditor named Sonia Reyes, to dig into Willow Creek HOA's financial history, not the land dispute directly, but the association's broader books, on a hunch worth testing. Sonia's early findings were troubling in a different way entirely. The HOA's reserve fund, which should have held nearly $400,000 after over a decade of assessments, showed a balance of barely $60,000, with no clear explanation in the public filings. I thought immediately of Linda Pham, the quiet treasurer who'd caught my eye at that first meeting. I found her contact information through the HOA directory and, carefully, sent a message asking only if she'd be willing to talk. Off the record, Linda agreed to meet at a coffee shop 2 towns over, somewhere no Willow Creek resident would recognize her car. She arrived nervous, glancing at the door twice before she even sat down, clutching a folder against her chest like armor. "I've wanted to say something for a year," she told me quietly. "Deborah controls every check, every invoice. I sign what I'm told to sign." I stopped understanding where the money actually goes a long time ago. Linda revealed that large, recurring payments had gone out over 3 years to a company called Hill Countryside Development, a contractor whose registered owner, according to state filings, was none other than Frank Voss himself, operating under a different business name. The payments were labeled landscaping and infrastructure planning for a project that, as far as Linda knew, had never actually broken ground anywhere in the existing subdivision, which raised an obvious, unsettling question about what exactly that money had funded. I asked Sonia to trace Hill Countryside Development's filings further. What she found tied the shell company to preliminary engineering surveys, dated nearly 2 years earlier, mapping out Phase 2 of a planned expansion, directly onto my 70 acres of eastern pasture. Deborah hadn't been reacting to a genuine boundary confusion at all. She and Frank had been planning this seizure for years, quietly commissioning site plans for land they didn't legally own, waiting only for the right forged paperwork to make the theft look procedural. Emma spent that whole weekend visit helping me repair a stretch of fence line near the creek, work she'd done alongside me since childhood, and there was something steadying about ordinary labor even while extraordinary threats loomed over everything else we owned. Linda agreed, carefully, to preserve copies of the financial records she had access to, understanding the risk to her own position on the board but increasingly unwilling to keep signing her name to numbers she no longer believed in. I didn't tell Deborah any of this, of course. Publicly, I remained the same quiet, stubborn rancher fighting a slow legal battle over a boundary line. Privately, the picture forming was no longer a dispute, it was a conspiracy with a paper trail. My mother's health stabilized slowly through that period, though the stress clearly wore on her. Emma came home for a long weekend, walking the eastern pasture with me at dawn, asking quietly whether we'd actually lose the land her grandfather once cleared. I told her the truth, that I didn't know yet, but that I finally understood what we were up against. An understanding, in a fight like this, was worth more than anger. She nodded, and for the first time in weeks, I saw her relax slightly. As the 60-day window narrowed, Deborah grew visibly restless in community forums, pushing residents to approve a special assessment to cover unexpected legal costs defending the community's interests, costs that, unbeknownst to most voting homeowners, were actually funding her own defense against my forgery claim. The special assessment passed narrowly, thanks largely to Deborah's tight control over meeting attendance and her habit of scheduling votes for mid-morning weekdays when most working residents couldn't attend in person to raise objections or ask pointed questions. I watched all of it unfold with a strange, growing calm. Every overreach, every manipulated vote, every dollar diverted through Frank's shell company was one more brick in a foundation that, sooner or later, was going to collapse under its own weight. Marcus, reviewing Sonia's financial trail alongside the forgery report, told me we now had grounds for something far larger than a boundary dispute, a potential case involving fraud, forgery, and breach of fiduciary duty that could reach well beyond civil court. He suggested quietly looping in the county district attorney's office, not yet with a full complaint, but enough to open an informal inquiry that would create an official record. One Deborah couldn't later dismiss as simply sour grapes from a disgruntled neighbor. I agreed, and we scheduled a preliminary meeting with an assistant district attorney named Patricia Nguyen, known locally for taking financial fraud cases seriously even when they involved respected community figures who usually escape scrutiny. For a brief stretch that autumn, things went quiet. The auction remained postponed. The DA's inquiry moved slowly but steadily behind the scenes, and Deborah, perhaps sensing resistance she couldn't fully explain, pulled back from her usual public aggression. I used that lull to focus on my mother, on the ranch's actual work, on mending fences that had nothing to do with lawsuits. Emma called every few days, cautiously hopeful, though I warned her repeatedly that quiet didn't mean the danger had passed. Linda Pham resigned from the treasurer position during that stretch, citing personal reasons in her official letter, though privately she told me she simply couldn't keep her name attached to books she now understood to be deliberately misleading. Her resignation left an opening on the board that Deborah quickly filled with a longtime friend, ensuring the remaining voting bloc stayed loyal. But it also meant Linda was now free, no longer bound by any official role, to speak more openly if needed. Sonia's investigation, running quietly in the background, uncovered something else during that calm stretch. Records showing Frank Voss's own home carried a second, undisclosed mortgage taken out 18 months earlier, well beyond what his visible contracting income could plausibly support. Sonia's voice on that call stayed steady, professional, the way it always did even delivering difficult news, and I'd come to rely on that steadiness more than I probably admitted. A calm counterweight to months of mounting dread. The community forum that week filled with speculation faster than facts could keep pace. Some neighbors defending Deborah reflexively, others quietly messaging me privately to ask if the rumors about a lawsuit were true. Unsure who to believe anymore, Sonia called twice that same afternoon. First to confirm the filing date discrepancy. Then again an hour later with something new. Records showing Frank had scouted equipment rental for the eastern pasture nearly 3 weeks before any sale was legally final. That detail mattered more than it seemed at first. Planning equipment logistics before a sale even closed suggested Frank and Deborah never expected serious resistance. Confident enough in their paperwork that consequences simply weren't part of their calculation. The Voss household, seemed, was financially overextended in ways their polished public image never suggested. Combined with the questionable HOA payments, a picture emerged of two people juggling debts and covering gaps with money that was never really theirs to spend. I filed that detail away without any immediate plan for it, though something in the back of my mind noted its potential significance. A family stretched that thin, hiding behind confident bravado, tends to make increasingly desperate choices when cornered. The DA's informal inquiry, meanwhile, requested formal copies of the HOA's banking records directly from the association's bank, a subpoena-adjacent request that Deborah, as president, was legally obligated to acknowledge, even if she could still delay full compliance for weeks. She stalled as long as she could, citing administrative backlog, but the request itself was now a matter of official record, and stalling only added to the growing pattern Patricia Nguyen's office was quietly documenting for a future case file. My mother, sensing the lull might not last, encouraged me one evening to simply enjoy it. "Your grandfather always said the land waits longer than any man," she told me over coffee on the porch, watching the last light fall over the pasture. I let myself believe, just for a few weeks, that the worst of it might be behind us. I should have known better. When they're losing, they regroup, and they come back with something far more reckless. The calm ended on a Thursday afternoon in late October, when Sonia called me directly, her voice tighter than I'd ever heard it, saying only, "You need to see something before you hear it from anyone else in town." Tyler wouldn't meet my eyes across the counter that morning, shuffling papers unnecessarily, and for just a moment I saw something other than bureaucratic indifference in his face, something closer to guilt, quickly buried beneath practiced professional distance. I filed a formal written complaint against the office's processing timeline anyway, less because I expected it to matter and more because I'd learned, by then, that every documented objection eventually became useful, even the ones that seemed to go nowhere at the time. What she'd found was the trigger for everything that followed. A newly recorded document at the county clerk's office, filed just 2 days earlier, showing the disputed 70 acres already transferred, in full, to Hill Country Site Development. The auction I thought was postponed 60 days had, according to this new filing, somehow already occurred. A private compliance sale, conducted under a rarely used bylaw clause that allowed the board, in extraordinary circumstances, to bypass a public auction entirely. I drove straight to the clerk's office, and Tyler Ross, visibly uncomfortable now, confirmed the filing was legitimate on its face, processed under Deborah's signature as HOA president. Dated the same week the injunction hearing had technically expired its 60-day hold. The judge's 60-day delay, turned out, had lapsed 3 days earlier than Marcus and I calculated. A clerical miscalculation on our end that Deborah's own attorney had apparently caught and exploited within hours, filing the private sale before we could react. It was a devastating, almost surgical strike, legal on paper, built entirely from our own missed deadline. And it meant my eastern 70 acres, on record, now belonged to a shell company controlled by Frank Voss. Effective immediately, I called Marcus in a fury I hadn't felt in months. He was equally stunned, immediately filing an emergency motion to void the sale based on the underlying forgery claim still pending before the same judge. But emergency motions take time even when urgent. Deborah, informed of the filing within hours through Tyler, didn't wait for any court to weigh in before acting. Within a week, survey crews and a single bulldozer appeared at the eastern fence line, clearing brush along what used to be my property. That was the image the whole community saw first. Not a courtroom battle, but heavy machinery on my land. A sold notice zip-tied to my own gate, and Deborah standing beside it, smiling for a photo someone posted to the neighborhood forum. I stood at that gate the morning the notice appeared, neighbors gathering along the road to watch, phones raised, waiting to see how I'd react. I said nothing. The notice myself, turned, and walked calmly back toward the house. Word spread through Willow Creek within hours that the marsh dispute had finally resolved in the HOA's favor. And for the first time, I understood exactly how thoroughly Deborah Voss had positioned herself to survive even a fraud investigation, by simply moving faster than the law. My mother watched the bulldozer from the porch, her hands shaking slightly around her coffee cup, and asked me quietly whether her father-in-law's land was really gone. I told her no, not yet, not really, no matter what a piece of paper claimed. I found myself, in quiet moments that autumn, grateful in a strange way for Marcus's steady presence through it all. A friend from law school who'd built an entire career defending exactly the kind of families Deborah assumed had no real recourse against institutional power. Emma, hearing about the sale over the phone, cried for the first time since this began. I let her, because pretending everything was fine would have insulted her intelligence. But I also told her, firmly, that this was the moment the case would actually turn. Marcus's emergency motion, filed within 48 hours, argued that a compliance sale executed while the underlying forgery claim remained under active judicial review was procedurally void regardless of any missed calendar deadline on our earlier injunction request. The judge, visibly irritated at the speed and manner of the transaction, agreed to an expedited hearing within 2 weeks, but explicitly declined to halt the bulldozers in the meantime, citing insufficient grounds for a new emergency stay without further evidence. Those 2 weeks were the hardest of the entire fight. Every morning brought new sounds from the eastern pasture: engines, chainsaws, surveyors' stakes hammered into ground. My grandfather once walked barefoot, checking on cattle before sunrise. I forced myself to keep working the case rather than the emotion, spending long nights with Sonia's growing financial file, cross-referencing every payment, every date, every signature, building something far more solid than a single forgery claim could offer alone. Sonia's deeper dig into Hill Country site development revealed the company's registered address was Frank Voss's own home, and its sole listed employee, on paper, was Chester Boyle, the same witness whose notarized statement had already crumbled under cross-examination months earlier. That connection alone tightened the noose considerably. The company that now legally owned my 70 acres was staffed, on paper, by exactly the two men most invested in fabricating the 1987 forgery, hardly a coincidence any judge could easily dismiss. Patricia Nguyen's office, having quietly gathered banking records for weeks, informed Marcus that the DA now considered the case strong enough to move from informal inquiry toward a formal criminal investigation, focusing specifically on forgery, fraud, and misuse of HOA funds. That escalation wasn't public yet, but it changed the entire shape of the fight. This was no longer just my civil dispute over a boundary line. It was becoming a criminal matter that could reach Deborah, Frank, Tyler, and Chester all at once. Deborah, unaware of the DA's shift, pressed forward publicly with plans for Phase 2, announcing at the next community meeting a proposed expansion adding 40 new home lots directly onto my seized land, framed as a boost to every homeowner's property value. The announcement briefly won her back some goodwill among residents excited by rising property values. Even as a smaller, more skeptical group, including Linda Pham, now speaking more openly, began quietly comparing notes about the HOA's finances at informal gatherings. That shift stayed with me through the following weeks, reframing every filing, every deposition request, every late night with Sonia's spreadsheets, not as a personal grudge but as due diligence owed to people who'd never had the tools to fight back themselves. I attended that meeting myself, sitting quietly in the back, watching Deborah present renderings of homes on my grandfather's pastureland with the same confident polish she'd used to threaten me over my unkempt fencing more than a year earlier. When the floor opened for questions, I stood and asked, calmly, whether the HOA's council could confirm the current status of the pending forgery litigation before residents voted to approve construction financing for Phase 2. The room went noticeably quiet. Deborah's attorney, caught off guard, admitted the litigation remained active and unresolved, a detail conspicuously absent from the glossy Phase 2 presentation. A ripple of uncertain murmurs moved through the crowd, the first real crack in her public narrative. Deborah recovered quickly, insisting the litigation was baseless and near resolution, but the damage was done. For the first time, homeowners who'd trusted her blindly for years were leaving that meeting with genuine, unresolved questions instead of comfortable certainty. That night, walking back to my truck, an older resident named Harold Whitfield stopped me quietly in the parking lot. He'd lived in Willow Creek since it was built and told me, in a low voice, that he'd never trusted Deborah's numbers either. Harold revealed something I hadn't known years earlier, before I'd bought back into the area full-time. Another homeowner had faced a similarly aggressive lien dispute with Deborah and had simply sold their house at a steep loss rather than fight her. That homeowner, Harold said, had moved out of state entirely, never speaking publicly about what happened. It was the first hint that I might not be Deborah's only victim, that this pattern of manufactured disputes might run deeper than my own case alone. I passed that information to Sonia the next morning, and within days she'd located the former homeowner, a woman named Priya Anand now living in Colorado, who agreed, hesitantly, to a phone call once she understood I was building a genuine case. Priya's story mirrored mine almost exactly. A sudden, obscure covenant violation, an inflated assessment lien, and pressure to sell quickly rather than fight a board she believed, correctly, held far more institutional power than any single homeowner could match. She'd sold her home to, of all buyers, another shell entity later traced back to Frank Voss, at nearly 40% below market value. Money she desperately needed at the time and never questioned closely enough to notice the pattern. With Priya's account added to the file, Sonia and Marcus began mapping a pattern across nearly a decade: small, aggressive land and property acquisitions, always funneled through Frank's shifting company names, always following disputes Deborah personally orchestrated as board president. It wasn't just greed for my 1,700 acres specifically. It was a long-running scheme, patient and methodical, and I happened to be the first target with both the legal training and the stubbornness to actually fight back instead of quietly selling out. That realization changed something in me. This was no longer only about protecting my family's land. It was about every quiet, intimidated homeowner who'd sold under pressure over the years, believing they had no real recourse against an HOA that seemed untouchable. Marcus, energized by the pattern evidence, requested the expedited hearing be broadened to include testimony from Priya Anand and financial records tracing Frank Voss's company history across all prior transactions, painting the full scope for the judge rather than just my case alone. The judge granted the broader scope reluctantly, noting the unusual complexity but agreeing that a pattern of alleged fraud was directly relevant to assessing whether my own forgery claim and the resulting compliance sale deserved to stand. Deborah, informed through her attorney of the expanded hearing, finally showed real cracks in public for the first time. At a chance encounter at the grocery store, she told me flatly that I was digging up ancient history that has nothing to do with anything. Harold told me later that half the cul-de-sac had gathered near the tree line that morning, drawn by the sound of the engine, and that even Deborah's staunchest defenders had gone quiet watching the old wooden structure finally come down. Reading those handwritten notes for the first time, in Marcus's office under fluorescent light, I felt something shift permanently in how I understood the entire ordeal. This hadn't been panic or overreach born of genuine confusion. It had been a plan, cold and deliberate, from the very beginning. I didn't go over there myself. Couldn't. Me on the porch instead, holding my hand the way she had when I was a boy, telling me softly that wood and steel could be rebuilt. But a family's resolve, once broken, rarely was, and ours wasn't broken. I said nothing back, only nodded the same way I had at my own gate weeks earlier, and watched her walk away faster than her usual confident stride, glancing back once toward her car as if checking whether anyone had witnessed the exchange. Frank Voss, meanwhile, grew visibly agitated at his own construction sites. According to two workers Sonia quietly interviewed, snapping at crews over minor delays, drinking more openly during work hours than anyone remembered from him before. The financial pressure was clearly mounting on both of them. The second undisclosed mortgage on their home, now compounding with mounting legal fees for Deborah's defense. All while Phase 2's promised construction financing remained tangled in unresolved litigation nobody could ignore any longer. Linda Pham, watching the tension build from the sidelines, reached out to me again, this time offering something new, a set of handwritten notes Deborah had once left behind after a late-night board session. Notes that explicitly referenced handling the Marsh situation before Chester gets nervous. Those notes, dated nearly 2 years before the forged 1987 amendment surfaced, proved premeditation in Deborah's own handwriting, a detail Marcus called, quietly, the kind of evidence that ends cases rather than merely helping them along. With premeditation now documented, Patricia Nguyen's office moved to formally open a criminal case, coordinating quietly with Marcus's civil litigation timeline so both fronts could advance without tipping Deborah off before search warrants could be properly prepared and executed. I knew none of the criminal timeline details at first. Only that Marcus advised me to keep working the ranch, keep caring for my mother, and let the machinery of law move at its own pace. However maddening the waiting became, the bulldozers, meanwhile, kept working my seized eastern pasture, clearing the old windmill site entirely, a structure my grandfather built by hand in 1962. Watching it come down from a distance was, without question, the lowest point of the entire fight for me personally. Emma flew home unannounced the weekend the windmill fell, having seen a neighbor's photo posted online before I could even tell her myself. We stood together at what remained of the fence line, saying very little, understanding each other completely without needing words. That night, I told her everything, the forgery, Priya Anand, Linda's notes, the criminal inquiry building quietly in the background. For the first time since this began, I saw something other than fear in her eyes. I saw the same stubborn resolve her great-grandfather once had. With Phase 2 construction financing still stalled and legal costs mounting, Deborah made her most reckless move yet, quietly instructing Tyler to backdate a second document. This one claiming an even older 1974 agreement had originally established the boundary Deborah now claimed. This new forgery was sloppier, rushed under pressure, referencing a surveying company that Sonia quickly discovered hadn't actually been incorporated until 1979, 5 years after the document claimed to have been notarized, an error careless enough to be almost unbelievable. Tyler, increasingly uneasy about his role, made a critical mistake. He filed the backdated document through the county system using his own office login rather than a generic terminal, leaving a digital timestamp trail Sonia's contacts in records management could later verify. When Marcus presented this second forged document to opposing counsel during a discovery exchange, even Deborah's own attorney seemed visibly unsettled, requesting a private recess that stretched nearly 40 minutes before returning with noticeably less confidence than before. Deborah, cornered by her own escalation, made the decision that would ultimately unravel everything. She instructed Frank to quietly begin selling off individual lots from the still disputed 70 acres to independent buyers, hoping to create good faith purchaser complications before any ruling could void the sale. Sonia later told me the warrant execution itself took investigators nearly 3 full days to properly index. The sheer volume of internal HOA messages spanning years of Deborah's presidency far larger than anyone, including Deborah herself, likely remembered having generated. 3 parcels sold within a single week to buyers who had no idea the underlying title remained under active forgery litigation. Each closing rushed through with minimal disclosure, funded partly by the same undisclosed mortgage debt already straining the Voss household. I learned about these sales from Marcus, who was furious, not at me, but at the audacity of selling contested property mid-litigation. A move that, rather than protecting Deborah, actually strengthened our case by demonstrating clear, willful disregard for the pending court order. The judge, informed of the rush sales during an emergency status conference, issued an immediate lease pendens notice across the entire disputed 70 acres, legally warning any future buyer that the property's title remained contested and unstable, effectively freezing further transactions overnight. Deborah's scramble to offload the land before losing it entirely had backfired, leaving 3 new, innocent buyers caught in a mess not of their own making, and leaving Deborah personally exposed to potential liability from those very buyers once the fraud became public. Frank Voss, facing both mounting personal debt and now the very real possibility of buyer lawsuits, began quietly liquidating other assets, a boat, a second truck, equipment from his contracting business, visible signs of a household in genuine financial freefall. Sonia tracked these liquidations carefully, noting each one added further weight to the picture of desperation building around the Voss household. A household that, on the surface, still projected the same confident, controlling image Deborah had maintained for over a decade. At the next HOA meeting, Deborah's presentation faltered noticeably, slides out of order, questions dodged with visible irritation rather than her usual smooth deflection, and for the first time, a resident openly called for her removal from the board entirely. The motion for removal failed narrowly, Deborah's loyal voting bloc still holding just enough sway. But the vote count itself, closer than anyone expected, sent a clear message that her grip on the community was weakening faster than she could control. Harold Whitfield, emboldened by the shifting mood, began quietly organizing informal gatherings among skeptical residents, sharing what he knew about Priya Anand's earlier ordeal, slowly building a coalition of homeowners no longer willing to accept Deborah's version of events without question. Deborah, sensing the coalition forming, responded with escalating aggression rather than caution, sending a cease and desist letter to Harold threatening defamation action over false rumors, a move that only confirmed, for many watching, exactly how far she'd go to protect her position. I stayed largely out of the community politics directly, letting Harold and Linda carry that front while I focused on the legal case itself. Though I privately made sure Marcus kept both of them informed of relevant filings they could reference honestly among neighbors. The criminal investigation, still quiet publicly, reached a turning point when Patricia Nguyen's office obtained a warrant for the HOA's full digital records, including internal messages between Deborah, Frank, and Tyler that none of them had ever expected outside eyes to see. Those messages, once reviewed, contained explicit references to keeping Marsh distracted with the mother's health situation and timing the emergency board.
Vote specifically around my hospital visits. Proof of deliberate exploitation.
When my mother learned, much later, that Deborah had timed her cruelest maneuver around a week my mother was fighting for her life in a hospital bed, something in her gentle nature hardened permanently. She stopped calling Deborah misguided and started calling her exactly what she was. I kept that particular detail from Emma a little longer, not wanting to add fuel to an already exhausting fight. But eventually she found out too, reading it in a court filing Marcus shared with our small legal team, and her resolve only sharpened further. Deborah, unaware of exactly how much digital evidence investigators now held, doubled down publicly, announcing at a tense meeting that Phase 2 would proceed as planned once frivolous litigation concluded, projecting confidence that no longer matched the private panic Sonia's sources described. Frank, drinking more heavily according to multiple worker accounts, was overheard at a job site saying the whole situation had gone too far to stop now. A comment one worker, uneasy, quietly repeated to Sonia during an otherwise unrelated interview about unpaid invoices. That comment, combined with the timing evidence and the 2 forged documents, gave Patricia Nguyen's office more than enough to move toward formal indictment preparation. Though prosecutors preferred building an airtight case rather than rushing charges prematurely and risking an acquittal later. Meanwhile, I quietly began a different kind of preparation entirely. One Marcus initially found unusual but ultimately agreed made strategic sense. Reviewing publicly available foreclosure and distressed mortgage listings across the county. The same kind of records I'd handled professionally for years. I wrestled with the decision longer than Marcus ever knew. Part of me worried that buying those notes made me no better than the people who'd manipulated paperwork against me. Until I reminded myself, repeatedly, that every step I took followed the law to the letter. I drove out to check on her within the hour, finding her already back on the porch, insisting she was fine, though she asked me twice that evening whether I thought Deborah might come back. A question I answered honestly. I didn't know, but we'd be ready either way. Emma, when I finally explained it to her over a weekend visit, sat quietly for a long moment before saying only, "You're not taking anything that isn't already theirs to lose. That you're just not looking away this time." I never forgot that sentence. I wasn't looking for revenge exactly. Not at first. I was looking for leverage. A way to ensure that whatever happened in court, the Voss family and their allies on the board would face consequences that actually mattered to people who valued property above almost everything else. Marcus made me walk through every possible angle before we moved forward, whether holding those notes might somehow taint my own forgery claim, whether a judge might view it unfavorably. In the end, we agreed the two matters were entirely separate. One a lawful purchase, the other a lawful defense. The second undisclosed mortgage on the Voss home, already flagged by Sonia months earlier, showed signs of missed payments beginning to accumulate, a detail visible in county recorder filings to anyone who knew precisely where and how to look for it. I did know exactly where to look. Years of title work had taught me how distressed mortgage notes sometimes became available for purchase from struggling lenders eager to offload risk. A niche, legal, entirely above-board corner of real estate few outside the industry understood well. Through a licensed note-buying broker I'd worked with professionally before, I began quietly inquiring about the Voss mortgage note specifically, discovering the original lender, a smaller regional bank, was indeed open to selling the increasingly delinquent debt at a discount. I purchased that note personally, under a small holding company I'd formed years earlier for unrelated title work, becoming, without Deborah or Frank ever suspecting it, their actual mortgage holder, the person now legally entitled to collect, or eventually foreclose, on their own home. Around the same time, Chester Boyle's modest property, mortgaged years earlier to help fund his failed business ventures with Frank, showed a similarly troubling payment history. I acquired that note too, through the same broker, quietly and entirely within the bounds of the law. Tyler Ross, still living in a small rental condo purchased with family help, wasn't a homeowner in the traditional sense, so his exposure, I understood, would need to come through the criminal investigation rather than any financial leverage I could arrange myself. By late that winter, I held direct financial leverage over two of the four people most responsible for stealing my family's land, entirely through legal, transparent means available to any qualified buyer, a quiet, patient counterweight to Deborah's years of manufactured schemes. Watching my mother prepare for that single day in court, choosing her outfit carefully the night before the way she once had for church, I understood she wasn't just testifying for me. She was testifying for her late husband and his father, both long gone, both still present in every word she planned to say. I told Marcus what I'd done, and he sat back in his chair for a long moment before saying only, "That's either the smartest or the most dangerous thing you've done this whole case." And then, after a pause, "Probably both. I wasn't reckless about it. I made no threats, sent no letters, took no premature action against either mortgage. I simply held the notes, patiently, the way you'd hold any legitimate financial asset, waiting to see how the criminal and civil cases would ultimately resolve." Deborah, still unaware of who now held her family's mortgage, continued her public campaign, filing a formal complaint against Harold Whitfield with the State Homeowner Association Oversight Board, accusing him of harassment for organizing informal resident meetings questioning HOA finances. That complaint backfired spectacularly once the Oversight Board, reviewing the underlying financial questions Harold had raised, opened its own preliminary review into Willow Creek HOA's governance practices, adding yet another official body now scrutinizing Deborah's decade of leadership. With 3 separate investigations now circling: civil litigation over the forged land transfer, a criminal fraud inquiry, and a state oversight review of HOA governance, Deborah's carefully built public image began fracturing faster than even her closest allies on the board could manage. Frank's contracting business, already strained financially, lost 2 significant clients that spring after word spread informally through local business circles about the mounting legal troubles. Clients unwilling to risk association with a company under active fraud scrutiny. The Voss household's finances, already stretched thin by the second mortgage and mounting legal fees, tightened further, and Sonia's contacts noted increasingly frequent, hushed arguments overheard by neighbors through open windows during the unusually warm early spring evenings. Deborah, cornered on nearly every front, made a decision that shocked even Marcus with its recklessness. She personally visited my mother at the ranch house one afternoon while I was in town, tempting, according to my mother's account, an intimidating final confrontation. My mother, 74 and unbowed, met Deborah at the porch steps and told her, calmly, that she remembered exactly what Frank had said to her father-in-law decades earlier, and that she intended to repeat every word of it under oath if necessary. Deborah left the ranch that day visibly rattled, and my mother, hands still shaking slightly from adrenaline once the confrontation ended, called me immediately, more energized by the exchange than frightened, a resilience that reminded me exactly who I came from. I reported the visit to Marcus, who added it to a growing pattern of harassment allegations that would later support a restraining order request. Though at the time we simply documented it carefully alongside everything else building steadily toward the upcoming hearing. The expedited civil hearing, delayed twice already by procedural motions from Deborah's attorney, finally received a firm date just 5 weeks out, set to examine both forged documents, Priya Anand's testimony, and the timing evidence tied to my mother's hospitalization. Patricia Nguyen's office, aware of the approaching civil hearing, made a strategic decision to hold formal criminal charges until immediately after, wanting the civil evidence fully aired publicly first, ensuring the community understood the full scope before any arrests became county news. I spent those 5 weeks preparing testimony alongside Marcus, reviewing timelines with Sonia, and coordinating gently with Priya Anand and Linda Pham to ensure their accounts, offered voluntarily, would hold up cleanly under whatever cross-examination Deborah's attorney attempted. My mother insisted on testifying too, despite her health, and her cardiologist, after reviewing her stable recent scans, cautiously cleared her for a single day in court provided she avoided unnecessary stress in the days immediately surrounding the hearing. Emma flew home for the hearing week entirely, taking a short leave from her spring semester, determined to sit in that courtroom for every single day. Understanding this fight was as much about her future on the ranch as it was about the past. Deborah, meanwhile, replaced her original attorney with a more aggressive litigator from San Antonio, someone known for scorched-earth courtroom tactics, a change Marcus read as a sign of genuine desperation rather than confidence heading into the hearing. The new attorney's opening strategy became clear almost immediately in pre-hearing filings. An attempt to discredit the forensic document examiner's credentials entirely, arguing his methodology lacked sufficient peer-reviewed standing to be admissible as reliable expert testimony in Texas courts. Marcus anticipated this move and had already secured a second, independently retained forensic examiner from a different firm entirely, whose preliminary review, conducted blind without knowledge of the first examiner's conclusions, arrived at nearly identical findings regarding both forged documents. With two independent experts now aligned, Deborah's attempt to discredit the forensic evidence lost most of its force before the hearing even began, though her attorney continued filing procedural objections designed more to exhaust our resources than to genuinely contest the underlying facts. As the hearing date approached, tension in Willow Creek reached its peak. Neighbors who once avoided my eyes now stopped me at the mailbox to quietly wish me well, having watched, over many months, the slow unraveling of a story they'd once fully believed. Harold Whitfield organized a small gathering the weekend before the hearing, informal and quiet, where nearly 30 residents showed up simply to hear directly from me what had actually happened, many admitting openly they'd been misled by Deborah's newsletters for years. I didn't ask anyone for anything at that gathering, only told the truth as plainly as I could, letting people draw their own conclusions. By the end of the evening, several residents had quietly offered to testify as character witnesses regarding Deborah's history of intimidation tactics. Deborah, informed of the gathering through a still loyal board member, responded by sending a mass community email accusing me of campaigning against the association and warning residents against being manipulated by a bitter litigant with a personal vendetta. Reading Tyler's full cooperation statement later, I felt an unexpected flicker of something like pity for him, a young man who'd clearly understood, too late, exactly what he'd been asked to become complicit in for the sake of family loyalty and a paycheck. That email, rather than rallying support, only deepened suspicion among residents who'd already begun questioning her judgment, and several forwarded it directly to Harold and Linda, further fueling the informal coalition Deborah had unintentionally helped create through her own overreach. The night before the hearing, I walked the eastern fence line alone, past the empty foundation where the old windmill once stood, and made a quiet promise to my grandfather that whatever happened tomorrow, I would not let this fight define bitterness into our family's future. My mother, unable to sleep either, joined me on the porch near midnight, and we sat together in comfortable silence, the way we had 100 times before, watching the same stars her husband and his father had watched from that exact spot decades earlier. Emma found us there eventually, wrapped a blanket around her grandmother's shoulders, and sat down between us without a word, and for a brief, unguarded moment, none of us spoke about lawyers or forgeries or mortgages at all, just family, together, on their land. The morning of the hearing arrived cold and clear. The courtroom filled faster than the bailiff expected, word having spread through Willow Creek that the Marsh case was finally getting its day. drawing far more spectators than the modest county courthouse usually saw. Deborah arrived with her new attorney, composed and sharply dressed, projecting the same confident authority she'd wielded at board meetings for over a decade. Though I noticed her hands gripping her folder just a shade too tightly as she took her seat. The 2 weeks of waiting for the judge's written ruling stretched longer than any period in the entire fight. Each morning beginning with the same reflexive check of the mailbox before I'd even had coffee, half expecting either vindication or disaster. Marcus warned me repeatedly not to read anything into the silence, that judges took the time they needed on cases this layered. But knowing that intellectually did little to quiet the low hum of anxiety that followed me through every chore on the ranch that fortnight. Willow Creek's usual rhythms continued oddly normal around us during that waiting period. Sprinklers running on schedule. Kids riding bikes past my gate. Life simply moving forward the way it does even in a neighborhood quietly holding its breath for a verdict. Marcus opened methodically, walking the judge through the forensic findings first. Both examiners' independent conclusions displayed side by side. The forged 1987 signatures, telltale hesitation marks magnified on screen for everyone in the courtroom to see clearly. Priya Anand testified next, her voice steady despite the distance she'd traveled, describing the eerily familiar pattern of pressure and manufactured disputes she'd faced years earlier, a story that visibly unsettled several residents hearing. For the first time, they weren't Deborah's only target. Linda Pham followed, presenting the financial records and her handwritten note discovery, explaining calmly how she'd watched money meant for community reserves quietly disappear into a contractor's shell company year after year, without ever fully understanding the destination until far too late. The 3 innocent buyers, once the full picture became clear, were relieved rather than angry, several later telling Marcus directly they'd sensed something rushed and strange about their closings even at the time, without quite being able to name what specifically felt wrong. Deborah's attorney cross-examined Linda aggressively, attempting to paint her as a disgruntled former employee acting out of resentment. But Linda's calm, unshaken responses, backed entirely by original documents rather than opinion, left little room for that narrative to actually stick. My mother testified next, describing both the decades-old story of Frank Voss's threat and, more devastatingly, Deborah's confrontational visit to the ranch house, an account the judge listened to with visibly narrowed focus, taking careful, deliberate notes throughout. When Deborah's attorney attempted to challenge my mother's memory, given her age and recent health issues, she answered so precisely, so calmly detailed, that the attempted attack only reinforced her credibility rather than undermining it, drawing a few quiet nods from the gallery. I testified last, walking the judge through the entire timeline personally, the initial letter, the forged document, the rushed compliance sale timed around my mother's hospitalization, and finally, carefully, the digital messages revealing deliberate exploitation of that exact vulnerability. Deborah's attorney, sensing the mounting weight of evidence, shifted strategy entirely during closing arguments, no longer denying the document's authenticity outright, but instead arguing that any irregularities were administrative errors rather than deliberate fraud, a defense that felt thin even as he delivered it. The judge, reviewing everything presented over 3 exhausting days, took the matter under advisement rather than ruling immediately, promising a written decision within 2 weeks, an agonizing wait, but one that felt, for the first time in over a year, genuinely winnable. Those 2 weeks stretched painfully, though the mood around Willow Creek had shifted permanently regardless of the eventual ruling. Deborah's authority, already fractured, seemed to dissolve further daily as more residents openly discussed what they'd witnessed unfold in that courtroom. Patricia Nguyen's office, having observed the entire civil hearing closely, decided the public record now supported moving forward with formal criminal charges without further delay, coordinating quietly with local law enforcement to prepare arrest warrants for Deborah, Frank, and Tyler simultaneously. On a Tuesday morning, just 4 days before the civil ruling was expected, sheriff's deputies arrived at the Voss home with warrants for fraud, forgery, and misuse of association funds, an arrest witnessed by enough neighbors that it became impossible for Willow Creek to look away any longer. Tyler Ross, arrested separately at the county clerk's office, cooperated almost immediately once presented with the digital filing evidence, providing a full statement detailing exactly how Deborah had directed him to backdate and file both forged documents over the preceding 2 years. Chester Boyle, questioned soon after, similarly cooperated, admitting his notarized witness statement had been entirely fabricated at Frank's request, motivated by old resentment over the failed 1987 land deal and a modest payment he'd received to sign the false affidavit. With 3 of the 4 conspirators now cooperating, the criminal case against Deborah solidified rapidly, prosecutors adding charges related to the deliberate targeting of my mother's medical vulnerability, a detail that drew visible outrage even among hardened courthouse staff reviewing the file. Deborah, released on bond, found her public standing utterly collapsed within days. The HOA board, scrambling under sudden scrutiny from the State Oversight Review, voted unanimously, a genuine unanimous vote this time, to remove her from the presidency immediately and permanently. Frank, facing his own separate charges tied to the shell company scheme, watched his contracting business effectively collapse under the weight of public exposure. Existing clients terminating contracts rapidly once local news outlets picked up the unfolding scandal in full detail. The civil ruling arrived exactly on schedule 2 weeks after the hearing concluded, and it was unambiguous. Both the 1987 and the later backdated documents were declared fraudulent forgeries, the compliance sale voided entirely, and full title to my 70 acres restored immediately to my name. The judge's written decision went further than I expected, explicitly criticizing the HOA board's conduct throughout, and ordering Willow Creek's association, as an institution separate from the individuals now facing criminal charges, to compensate me for legal costs and demonstrable property damage. That property damage included, specifically, the destroyed windmill, and though no ruling could truly restore something my grandfather built by hand in 1962, there was a strange, quiet closure in hearing a judge formally acknowledge exactly what had been taken from my family. The 3 parcels Frank had rushed to sell mid-litigation reverted to a complicated but resolvable status, with the lease pendens notice protecting those innocent buyers' eventual claims against Frank and Deborah personally rather than against my restored title, exactly as Marcus had anticipated. With the civil case resolved and criminal charges mounting, I finally decided the moment had come to address the financial leverage I'd quietly held for months, the delinquent mortgage notes on both the Voss home and Chester Boyle's modest property. I hadn't purchased those notes out of vindictiveness. Not really, but out of a hard, practical understanding that people who'd shown no hesitation destroying a family's legacy over land deserved to face the exact same legal, procedural machinery they'd tried to weaponize against me. The Voss mortgage, already months delinquent before their arrests, and now hopelessly so given Frank's collapsed business and Deborah's mounting legal fees, reached the contractual threshold for foreclosure proceedings, a process I initiated through the same broker, entirely within standard legal procedure. I felt no particular satisfaction filing that paperwork. Only a grim sense of symmetry. The same compliance foreclosure mechanism Deborah had twisted to steal my land was, in its legitimate form, now simply working exactly the way foreclosure law was always meant to. I never learned, and never asked, exactly what Deborah told herself in those quiet months after everything collapsed. Whether she still believed, somewhere, that the land had rightfully been hers to take, or whether the truth had finally, fully caught up with her. Chester Boyle's property followed a similar path shortly after, his own finances having never recovered from decades of failed ventures with Frank. The delinquent note I held reaching foreclosure eligibility almost exactly as his criminal cooperation agreement was finalized with prosecutors. Word of who actually held both mortgage notes spread through Willow Creek almost as quickly as the arrests had, and the community's reaction surprised me. Less shock at the revelation than a kind of grim, satisfied recognition of poetic justice finally arriving. I found myself, that afternoon, thinking less about Deborah Voss specifically and more about every ordinary family who never gets the resources or the training to fight back against an institution willing to lie, and about how much luck, as much as effort, had shaped my own outcome. I drove past the old Voss property once, weeks after the auction notice posted, not out of triumph but a kind of necessary closure, watching a young family unload moving boxes into a house that had once been the command center of so much scheming against mine. The audit Linda and Harold commissioned took nearly 4 months to complete, uncovering smaller irregularities beyond the major fraud already exposed, inflated landscaping invoices, a suspicious insurance policy switch, details that painted an association that had drifted from oversight long before Deborah ever targeted my land specifically. Those findings became the foundation for the new bylaws, requiring 2 independent signatures on any expenditure over a modest threshold and mandatory public posting of board meeting minutes within 72 hours. Small procedural changes that would have made Deborah's entire scheme far harder to execute from the start. I didn't stop. Whatever satisfaction there was in that moment lived quietly in my chest. Private and unspectacular. Nothing like the theatrical reckoning I might once have imagined wanting. Back before I understood how patience actually wins these fights. Deborah, informed by her attorney that her own home now faced foreclosure from the very man whose land she'd stolen, reportedly went silent for several days, according to a neighbor who still occasionally spoke with her, refusing all further comment to anyone in the community. I want to be clear about something. Even now, I never once threatened either family personally, never gloated publicly, never used the mortgage leverage as anything other than a legitimate financial instrument allowed to run its lawful, unhurried course through proper channels. Marcus, reviewing my approach afterward, called it the cleanest kind of justice precisely because it required no bending of rules, no favors, nothing beyond the same legal system Deborah herself had tried, and failed, to manipulate for her own benefit. The foreclosure proceedings moved through the same county courts that had handled my forgery case. Slower than criminal proceedings but methodical, giving both Deborah and Chester every legal notice and opportunity to cure their debts that the law required, opportunities neither could financially meet. Frank, facing both criminal fraud charges and imminent foreclosure simultaneously, accepted a plea agreement that spring, cooperating fully with prosecutors. Regarding the shell company scheme in exchange for a reduced sentence, a decision that further isolated Deborah as her final ally turned witness. Deborah, now facing trial largely alone, with Tyler, Chester, and eventually Frank all having cooperated against her, finally accepted her own plea agreement rather than risk the maximum sentence a full trial's guilty verdict could carry given the overwhelming, unified evidence. Under the terms of that agreement, Deborah pled guilty to forgery, fraud, and misuse of association funds, receiving a sentence that included restitution, a lengthy probation period, and a permanent bar from ever serving on any homeowners association board in the state again. The foreclosure on the Voss home, unrelated legally to the criminal case but running its own parallel course, completed not long after. The property eventually sold at a standard courthouse auction. The proceeds applied first to the outstanding mortgage debt I'd legally acquired. I felt, watching that auction notice post publicly, a strange, quiet weight lift, not celebration exactly, but the settling of a scale that had been tilted so violently against my family for so long finally, legitimately, coming back level. Chester Boyle's small property followed a similar foreclosure path shortly after, his cooperation with prosecutors earning him a lighter sentence than Deborah's, but no protection from the financial consequences of debts he genuinely failed to pay, regardless of who now happened to hold the note. Willow Creek HOA itself, under new interim leadership led partly by Linda Pham and Harold Whitfield, began the long process of rebuilding trust, commissioning an independent financial audit and adopting new transparency bylaws explicitly designed to prevent any single board member from ever again wielding unchecked authority. I was invited, somewhat to my own surprise, to a community meeting months later, not as a defendant or a litigant this time, but simply as a neighbor, to discuss how my formerly disputed 70 acres might eventually rejoin conversations about the area's future. On my own terms, I declined any formal role in HOA governance myself, having no interest in the kind of institutional power that had so thoroughly corrupted Deborah. But I did agree to a friendly, informal easement allowing a small community walking trail along a portion of my restored eastern fence line. That small gesture, offered freely rather than extracted through threat or forgery, did more to rebuild goodwill between my family and the surrounding community than any courtroom victory ever could. A lesson in generosity I tried to model deliberately for Emma throughout that difficult year. Emma, having watched the entire fight unfold from her first year of college through her final semester, changed her senior thesis project entirely, focusing instead on sustainable land stewardship and legal protections for family agricultural land against exactly the kind of institutional overreach we'd survived. My mother, her health gradually stabilizing further into that following year, took quiet, deep satisfaction in one detail above all others, the rebuilding of the windmill, a faithful reconstruction Emma helped design using old photographs and my grandfather's original hand-drawn plans. We held a small gathering the day the new windmill's blades first turned in the wind. Nothing elaborate, just family and a handful of neighbors who'd stood by us, including Harold, Linda, and even Priya Anand, who flew in from Colorado specifically for the occasion. Standing at that fence line, watching the blades turn against a clear autumn sky, I thought about how close we'd come to losing everything, not just the land itself, but the fundamental sense that fairness, patiently pursued, could still triumph over raw, entrenched power. Sonia Reyes, whose quiet investigative work had unraveled so much of the scheme, became something between a colleague and a friend over that year, and I later hired her formally to help other homeowners in similar disputes. Work I found unexpectedly meaningful. Marcus and I stayed close as well, occasionally collaborating on cases involving exactly the kind of HOA overreach that had nearly cost me everything. Both of us driven now by a shared understanding of how vulnerable ordinary families could be against institutions willing to lie. Linda Pham, elected treasurer again under the new transparent bylaws, made sure every dollar of Willow Creek's reserve fund was publicly itemized quarterly. A small, steady act of accountability that would have prevented the entire scheme had it existed a decade earlier. Harold Whitfield, now serving on the reformed board himself, often told newer residents the story of the Marsh case not as gossip, but as a cautionary lesson in why ordinary homeowners needed to stay engaged, ask questions, and never assume institutional authority meant institutional honesty. Deborah, serving out her probation quietly in a smaller rental across town after the foreclosure, was occasionally spotted at the grocery store by residents who still recognized her, though most, by unspoken agreement, simply let her pass without comment. The fight long since settled. Frank, similarly rebuilding a far more modest life after his contracting business collapsed entirely, took a job eventually with a competitor's crew. Quiet, humbling landing for a man who'd once dreamed of 40 new home lots carved from land that was never legally his to sell. Tyler Ross, having cooperated fully throughout, avoided serious jail time but lost his position at the county clerk's office permanently, a professional consequence that followed him as he relocated eventually to another county. Starting over somewhere his family's name carried no complicated history. Chester Boyle, older now and living modestly after his own foreclosure, occasionally sent word through mutual acquaintances that he regretted his role in the whole affair, though I never sought him out directly, having found, somewhere along the way, that I no longer needed his apology to feel whole. As for the 70 acres themselves, restored fully to Marsh family ownership, I eventually placed the land into a conservation easement alongside the rest of our 1,700 acres, ensuring no future board, no future Deborah, could ever again manufacture a claim against it. Emma graduated that spring and came home for good, exactly as she'd always promised, taking over daily operations of the ranch's sustainable grazing program, while I gradually stepped back from active legal practice to spend more unhurried mornings walking the land beside her. My mother lived to see 2 more full seasons of wildflowers bloom across the restored eastern pasture before she passed peacefully in her sleep that following winter, having spent her final months exactly where she wanted to be, home, on land that was, once again, unquestionably ours. I think of her often at that fence line, remembering her steady voice on the witness stand, remembering how she never once wavered even when Deborah tried to use her own frailty as a weapon, remembering that courage, in the end, comes in many quiet forms. The windmill still turns today, exactly where the original once stood, and neighbors walking the community trail sometimes pause to read the small plaque Emma installed at its base, honoring 3 generations of a family who refused to let their legacy be stolen through fraud. Willow Creek Estates, under its reformed leadership, became something of a quiet model for other associations in the county, occasionally visited by homeowner groups from neighboring communities looking to understand how transparent governance could actually prevent the kind of abuse Deborah had gotten away with for years. I never set out to destroy anyone. I only ever wanted to keep what my family had built. Honestly, patiently, and legally, and in the end, that was exactly enough. The truth, given time and proper process, proved sturdier than every forged signature Deborah Voss ever produced. Sometimes, on quiet evenings, I still walk the full 1,700 acres alone, tracing the same fence lines my grandfather once walked, understanding now, more deeply than ever, that land holds memory the way people do, patiently, stubbornly, waiting for the truth to finally come home. Emma asks me sometimes if I ever regret how far the fight went, and I always give her the same honest answer. I regret only that it had to happen at all, never that I stood my ground until every acre and every ounce of dignity was fully restored. The gate at the eastern fence line still bears a small, faded scar where Deborah's sold notice once hung, a mark I chose deliberately never to sand away, a quiet reminder that some victories are worth remembering exactly as hard-won as they truly were.